Okay, so everybody okay? Sorry for starting class a bit late. I have a long day today. I have many meetings and consultation hours and also case to prepare. So juggling with many other things. As you all may be aware, I'm running for election for bar council as well. So busy with campaigning as well. There's so many issues to be answered, so many allegations to be answered. This is maybe a good time for me to say that you guys should later on, if admitted to practice. I know I'm fully aware of the issue of the with LPQB. We discuss USIM issue all the time. We are trying very hard in the council to convince the relevant person that USIM should be immediately recognized without need to go through, all these exams and things like that. But at the same time, the Bar Council also want to table the amendment, or rather the new Legal Profession Act, which will introduce a common bar course, CBC. Of course, common bar course is another issue. Many universities objected to it. We have reduced the scheme of CBC into something which is practical to everybody. Instead of initial idea of common bar course is for you to sit for the course for 15 months after you graduated, before you can even start your chambering. And then now has been reduced to you might need to sit for a certain course during your pupillage, in your 9-month pupillage, and then you don't have to maybe take another exam, but that is still at proposal stage. So just bear with us, bear with the Bar Council. The decision ultimately is with LPQB, Lembaga Legal Professional Qualifying Board, and the LPQB is chaired by the Attorney General, Peguam Negara, and Attorney General until now has not made any decision. So perhaps in the near future, doa, insyaAllah, USIM will get a full recognition without any, having to have special requirement or special tests or special exams. I look forward into that, and that is also the reason why I come here, not here, but USIM, to agree to teach you all the civil trial advocacy, because this subject is a requirement by LPQB. Inshallah, I'll try to do my best to educate you guys, to prepare all of you for the real world, I would say, and also to help USIM to get the recognition, inshallah. Okay, so that is if you are in practice after this, my personal objective is to have more Muslim lawyers. Okay, more Muslim lawyers in the Bar Council. Okay, the Council all this while is,
dominating.
Sometimes, how to say, doesn't really balance the view. Of course, we recognize the rule of law, the right of the fundamental liberties and rights in the federal constitution. Yes, but at the same time, in the same federal constitution, there are many rights that is protected. For example, the freedom of religion, Islam as the religion of federation, the right of Muslim to propagate Islam, and then the right of Muslim to set up institutional fund like Baitul Mal, and the right of Malay, special privilege of Malay in terms of ownership of property, in terms of Bahasa Melayu, in terms of certain privilege provided and accorded by the federal constitution. So some quarters might just fight for some part of federal constitution, which is fundamental liberties, freedom of religion and thoughts. Okay, they say that everybody should enjoy freedom, and to some extent sexuality freedom. Okay, the right of transgender, the rights of lesbian, gay and bisexual people, but they forget or purposely forget that Islam as the religion of federation is also the most fundamental feature of the federal constitution. So if we recognize Islam as a federal religion, the religion of federation, somehow we must also respect the Islamic principle and point of view, right? And the federal constitution doesn't recognize the third gender. There is no articles which recognize the third gender. It is male and female. There's no third gender. There's no transgender, right? There's no, and the federal constitution also doesn't recognize the right to having spouse with the same sex. Hence, doesn't allow for lesbian, gay, and bisexual activities. So all this has not been balanced before. Okay? In the Bar Council, they fight for certain rights, but they neglect other rights sometimes. Okay, so we as a Muslim lawyer, you as a potential Muslim lawyer, must involve in all these activities. There are so many avenues and so many platforms for you to excel, for you to learn more in practice. Orang Islam, peguam-peguam Islam, mesti ada kekuatan, mesti jadi lawyer yang bagus. Sekarang ni kalau kita tengok lawyer-lawyer yang bagus adalah nama-nama bukan Islam. They excel, jadi lawyer-lawyer yang hebat, a senior practitioner. Everybody know mendiang kapal sing. Semua orang tahu siapa ramai lagi, Hisham Tepote, Ram Kapal dan sebagainya. Right? Tetapi kita nak kena tunjukkan bahawa orang Islam juga boleh. Orang Islam yang bukan takat Islam, tetapi orang Islam yang berpegang teguh kepada prinsip-prinsip Islam. Tak ada dah. Saya nampak dalam Malaysia ni dua saja full of generation that can do that. Satu, UIA, to be frank. Keduanya USIM. Okay, UIA pun kadang-kadang tak berapa nak boleh control. So, we as a Muslim lawyers must excel. Kena tunjuk orang Islam boleh jadi lawyer yang hebat. Boleh fight for justice. Right? Boleh speak good English. Boleh argue, boleh give a good argument. And involve in activities of the Bar Council. Involve in activity kemasyarakatan. And then, baru orang nampak bahawa orang Islam ni bukan just, what do you call that? buih-buih di lautan, or whatever that ustaz-ustaz selalu cakap. Saya bukan ustaz, but I have this semangat. Okay, that is kuliah motivasi malam ni. Then we go straight to our lesson. InsyaAllah today kita sambung. We continue what we learned before. I believe that last class we talked about the type of questions. We talk about how to about the witness statement, how to prepare the witness statement generally, and I think I explained to you the leading question, non-leading question, and things like that. And then I discuss also some about the application that you can make in court for pre-trial application, for example, this application for discovery and interrogatories. Okay, tonight I want to talk in detail, more detail about the first is the cross-examination in court, and later on I will discuss with you how to argue in court and how to prepare perhaps a written submissions. I will share to you the slide today. Okay. In the last class, I explained to you about the three type of questions. Leading questions, open-ended non-leading question, and close-ended non-leading question. If you remember, then there are three sessions in the trial. First is examination in chief. Second is cross-examination. Thirdly is re-examination. Alright? During the examination in chief, or when you prepare your written submissions, you remember that I said examination in chief can be conducted by way of witness statement. And when the witness statement is taken as read, okay, dikira sebagai dibaca, maksudnya you have completed your first session of examination in chief. And question allowed in examination in chief is a close-ended non-leading question. You cannot ask leading question during examination in chief. Hence, in your witness statement, you cannot ask leading question. You must ask a non-leading question. Okay. The second session is a cross-examination session, whereby you can ask any question that you want, including a leading question. You remember that leading question, the answer to leading question must be either yes or no. Leading question doesn't require any explanation. If you go to court, you will see the lawyer will ask a question which requires yes or no. And when the witness is trying to explain, the lawyer will cut. No. Just answer my question, yes or no. You don't have to explain, because your lawyer, during re-examination, the third session, will ask you and give you opportunity to explain. But in cross-examination, the best tactic is not to allow witness to explain. Okay? Don't allow witness to explain in cross-examination, because you want to lead your answer to the witness and take the witness to your track or strategy. That is why you lead. Okay? You remember I give you example. If you ask non-leading question, for example, apa yang berlaku pada 1 hari bulan Januari 2020. Okay, and the witness will start to explain everything daripada bangun pagi, sembahyang subuh dan sebagainya. Okay, leading question, you will direct the witness directly to the particular event and ask him particularly about that situation, whether he agrees with you or not. And leading question also can be used to trap the witness. Okay, I will explain to you later in the cross-examination. So, and during re-examination again, you cannot ask leading question. I recap, you cannot ask leading question during examination in chief as well as re-examination. You can only ask leading question during cross-examination. Alright? So now we go to the 10 commandments of cross-examination. 10 commandments of cross-examination ni developed by Sir, I can't remember the name already. What is his name? My one Queen Counsel in England. Later on, if I remember the name, I will tell you. So he developed the 10 commandments of cross-examination, meaning the 10 basic principles of cross-examination. How the do's and don'ts of cross-examination. The thing that you must master to be able to effectively cross a witness. Remember, cross-examination, you must ask leading question. Yeah? Okay. The first commandment is, of course, prepare. This is really not a commandment for cross-examination, but rather the commandment for filing a legal action in general, that you must prepare. Preparing means you must read from cover to cover. I always say this, read from cover to cover. Before you cross-examine a witness, you must baca all documents related to that witness from cover to cover. Every single words, every single sentence of the document, you must read before you cross-examine. Just imagine, guys, you need to cross-examine a medical expert. Again, I use medical negligence as example. You need to cross-examine a consultant, a heart surgeon. Okay, you want to show that the consultant heart surgeon has done something wrong in his procedure, in his bypass procedure, for example. Okay, you want to discredit the report of the expert, which is the report of the medical expert, the heart surgeon just now. How you want to refute his finding? How you want to discredit his report when you don't even understand the medical terms, when you don't even understand the procedure, the surgery procedure. So what you must do is you must read from cover to cover. Tak boleh malas. If you want to do general litigation, you must read everything. And you must understand. Okay? You must be able to comprehend things. Lawyers must be able to open his mind and take new things and learn new things and be an expert himself to be able to cross-examine an expert. And then when you read from cover to cover, you will find a loopholes, a discrepancies in the document that you can use to attack the witness. For example, if you are crossing the medical expert just now, you read his report from cover to cover, you baca the medical report, then you will find the loopholes. Oh, okay, this medical report says that the operation is A, method A. But when you read, you Google, you cari the journal, medical journal apa semua, you will find that in this kind of case, the correct procedure is method B. Right? So this doctor used method A, but the correct procedure is method B. Then you can ask the question to discredit that medical expert, then why do you agree with me that method A is not the only method in this kind of case? Remember, leading question, do you agree with me that method A is not the only procedure in this case, right? And then the doctor will say, yes, I agree. Then do you agree with me there is method B? Yes, I agree with you. Do you agree that in the case of a patient, when patient is underage, the best and suitable method is method B? Oh, I don't agree. Method A also real. Okay, now I refer you to this journal from a British Royal um, Society of Surgery, which says that in this kind of patient, the underage patient, method B is more preferable. Do you agree with this finding? No, I don't agree. But do you agree that this society is a very reputable society? Yes, I agree. Then I put it to you that the more acceptable method is method B, as stated by the Royal Society of Surgeons of London, which is a recognized and reputable society. Dia pun kena jawab, yes, I agree with you. You know, so you find loopholes, you find discrepancies, and you attack the witness. And then at the same time, preparation means you check the background of the witness. You are in the era of internet, IR 4.0. Orang Islam kena betul-betul kuasai IR 4.0. IR 4.0 means what? Industrial Relation 4.0 means big data, Internet of Things. You need to understand the internet. You need to use internet to gain knowledge. So, everything ada kat Pakcik Google. Okay? Everything is on Pakcik Google. So, you can actually do your background search on the witness to discredit him through internet. Okay, for example, you nak cross seorang professor in um, uh, engineering, for example, professor in engineering. So you pun check, oh, Professor Khalid, for example, you pun check dekat Google, Professor Khalid. Okay, siapa dia? Apa background dia? Dia belajar dekat mana? You dah tahu semua ni. Oh, dia tengok-tengok ada. You will find an interesting thing about him. Okay, bukan interesting thing about him is his scandal. Bukan scandalous benda. Tidak. Tapi interesting things means something that you can use to discredit his reputation. For example, you check, oh, Professor Khalid ni pernah been terminated from one position in whatever institution, for example lah. And then you can use it to discredit him. You esok you boleh tanya, do you agree with me, Professor, that you have been expelled from the research institute in Singapore, for example? Yes, I agree with you. Do you agree with me that your expulsion is because of your research that is against the some established science, for example, maybe. Don't people agree? And then do you agree with me because of that? I put it to you that you are not a qualified person to testify on this matter. He might agree, he might disagree, but you have discredited him with the background research that you have done against him. Okay, prepare also means you must know the answer. Okay, remember that you cannot ask, lawyer will not and cannot ask question that we don't know the answer. Kita tanya soalan bukan macam student tanya soalan kepada lecturer. Student ask question to the lecturer to know the answer. But lawyers ask question to witness not to know the answer. The lawyer already know the answer, but to question the knowledge of the witness, to question the witness punya stand, to question the credibility of witness. So you must know the answer to your question. And preparation also means you make a notes, a proper notes. I have conducted trial for almost 19 years. Hundreds of trials. But until now, I still prepare cross-examination notes. Until now, in type written. I can type written notes. I can tulis what is the area. You remember your table of facts and evidence. I explain to you a table of facts and evidence that you can use to prepare your witness statement. That table of facts and evidence can also be used to prepare your cross-examination. Okay, look at the table of facts and evidence again. When you see here, this is element, and then when you see in your witness column is the, for example here, defendant, second defendant. Second defendant means your opponent, your plaintiff. So the witness who can testify about the second defendant failed to take blood sample to rule out virus infection is the second defendant himself. So you must prepare your cross-examination points on this point to the second defendant. Okay? You use your table of facts and evidence to prepare your notes. That is commandment number 1, which is prepare. Alright? Prepare. Number 2, second is objective. You must know what is your objective in cross-examining that particular witness. You must know what is the point to make. This witness, apa targetnya? You nak suruh dia cakap apa? Ultimately, what do you want the witness to say ultimately? Okay, ultimately, for example, in the case of medical negligence just now, you want to cross-examine the nurse who actually instructed by the doctor to check the patient. Tapi dalam kepala you dah ada, my ultimate objective against this witness is I want this nurse to say that I have not been instructed by the doctor to take the blood sample. Saya tidak diarahkan untuk take the blood sample. Of course, the nurse will not say it straight away. You kena tanya slow sampailah dia buka cerita, yes, I have not been instructed to take a blood sample. But you know in your head your objective. Selagi mana dia tak cakap benda tu, selagi mana you tak dapat that answer from her or from him, you takkan lepaskan dia. So, because you know your objective, point to make. What is confession or admission to be extracted? You want this witness to confess on something. Okay, you want this witness to confess that memang dia tak ambil ujian darah macam tadi. So that is your objective. And also what is the story you want to establish. Ini objektif yang you perlu set. Tulis dekat kertas. Witness, defendant nombor 1. Nurse bernama Fatimah. Objective number 1. Fatimah must say that he was not instructed by the doctor to take blood sample. Objective number 2. Fatimah tak diarahkan untuk check the patient every day. Know your objective. And then you buat your notes. Only when you have your objective will you conduct the cross-examination in a proper way. Otherwise, you akan tanya soalan without any objective. Number 3. The third commandment is baby step. This is very, very, very important in cross-examination. You must learn it and you must now pay attention to this important commandment. Baby step. I can tell you, if you master this third commandment, you will be a good cross-examiner in any trial. If you master this step, you will be a good cross-examiner in any trial. What is baby step? Baby step is baby step lah. Baby taking a step. How does baby take the step? One by one, right? One by one. Slowly, baby will start crawling. And then we start, try to stand. And then after standing, we start slowly moving. And then we start take a step. So this baby step means here, you must lay down the foundation. You know the objective, right? You tahu apa yang you nak extract daripada this witness, but you don't ask him straight away. You lay down the foundation. Lay down the foundation means you slowly take the witness to agree with basic things before asking specific question. You tanya soalan yang dia akan jawab ya dulu. Before you conclude and nail him. Before you conclude and make him confess. Before you conclude and make him admit certain things that you want. But you must ask basic question. In theory, it doesn't, I know you don't understand what it means by baby step because this is a theory, but I will give you an example. The example is like this. For example, in the case of breach of fiduciary duties by a director, for example, you sue the director of the company because director of the company had failed to ataupun had allowed misappropriation of money. Okay, had allowed the company's money to be used for fraudulent purpose. Saman pengarah syarikat yang membenarkan company gunakan duit seseorang guna duit company for fraudulent purpose. Okay, you want to say that the director had breached fiduciary duties. Okay. Kalau you tak baby step, you ask straight away, do you agree with me that by allowing your staff to withdraw money from the company, you are actually committing breach of fiduciary duties? Rasa dia jawab apa? Do you agree with me that by allowing the company, the company's staff to withdraw the money from the company without authorization, you are actually in breach of your fiduciary duty as a director? Definitely the winner will say no. I tak breach apa-apa. Right? Because you ask a point blank question. Contoh, do you agree with me that you murder that person? Setuju ke tak awak bunuh orang tu? Ada orang nak cakap, ya saya setuju. Then tak payah bicara lah. Right? If you ask a straight question, it's a leading question, but if you ask straight away, nobody will agree with your suggestion. Nobody will agree. Do you agree that adakah kamu setuju bahawa kamu telah melakukan satu pencerobohan terhadap tanah plaintiff kerana membuat rumah di atas tanah plaintiff? Dia akan jawab apa? Saya tak setuju. Nobody will agree with you because they have appointed lawyer and in the first place they want to fight the case. Definitely they won't agree with you. If they agree, then tak payahlah pergi bicara. Ambil JID sajalah, judgment in default. How to make a witness agree? It is by way of baby step. For example, in the case of director, contoh, I said to you just now, slowly take witness to agree with basic things. Lay down the foundation. You nak cakap director breach fiduciary duty sebab allowed tadi. Okay, you tanya apa? First you tanya, Tuan Malik, for example, nama director, Tuan Malik, setuju atau tidak dengan saya bahawa sebagai seorang pengarah, pengarah mempunyai akses kepada dokumen-dokumen syarikat? Dia akan jawab, yes. It's a simple thing. It's a basic thing. You takkan jawab no lah. Oh tak ada akses, tak logik. Setuju ke tak seorang pengarah mempunyai akses kepada dokumen syarikat? Setuju. Okay, then you take a step further. Setuju ke tak antara dokumen-dokumen yang berada di dalam kawalan pengarah adalah dokumen tentang statement of account ataupun penyata-penyata akaun syarikat? Setuju? Setuju ke tak anda sendiri sebagai pengarah mempunyai akses dan kawalan terhadap keluar masuk wang dalam syarikat? Setuju? Setuju ke tak bahawa anda merupakan seorang penandatangan yang diberi? Setuju ke tak bahawa sesiapa saja yang nak keluarkan wang syarikat mesti mendapatkan kelulusan daripada anda dan mendapatkan tanda tangan anda? Setuju? Setuju ke tak dalam kes ini yang mengeluarkan duit syarikat adalah si Polan? Setuju? Jadi memandangkan anda setuju bahawa semua pengeluaran duit syarikat adalah perlu melalui anda, setuju atau tidak kalau saya katakan si Polan ini mengeluarkan duit yang dikatakan secara salah ini juga melalui anda? Dia akan tak setuju. Ya, tapi tadi anda sendiri cakap, baru kita tekan. You know? Dia dah jawab, saya tak setuju yang tu. Tapi tadi, Tuan Malik, tadi anda sendiri katakan bahawa setiap transaksi, anda sendiri setuju dengan saya bahawa setiap transaksi keluar masuk, anda yang perlu tanda tangan dan anda yang adalah penanda tangan dan anda yang ada akses dan anda yang ada kawalan terhadap dokumen dan anda juga setuju antara dokumen yang anda kawal adalah statement of account dan juga keluar masuk wang. Dan saya katakan si Polan mengeluarkan wang daripada syarikat yang mana ia mesti melalui anda. Tak ada jawab dah. And in that moment, the witness, whether the witness setuju atau tak, dah tak penting. It doesn't matter anymore. Because it is clear that you have laid down your foundation. It is clear that the witness had agreed to basic things and the witness cannot after that turn away and say something else. And even though the witness says something else, the witness will look, for lack of better words, stupid. Nampak macam tipu. Nampak macam nak evade the answer. Nampak macam nak lari. Betul tak? Right? Nampak kan? Nampak? That is example of baby step. Soalan-soalan tadi soalan simple je. Sebagai pengarah, you ada access pada dokumen. Sebagai ni. Take for example the case of trespass. Pencerobohan. Tadi yang saya cakap, kalau kita tanya setuju atau tidak bahawa plaintiff, bahawa kamu defendant telah melakukan satu pencerobohan apabila kamu telah membina rumah di atas tanah plaintiff, dia akan jawab tak setuju, confirm. Saya tak setuju. Mana ada saya ceroboh? Right. So how to baby step? How to baby step? You tanya mula-mula dulu. Tuan setuju ke tak kalau saya katakan bahawa tanah tuan punya tanah ini sama ada kita memiliki satu tanah ataupun tidak ditentukan oleh geran. Tuan setuju tak? Setuju lah. Setuju. Jadi kalau kita ada geran yang menyatakan ini tanah kita, maka betul lah tanah itu tanah kita. Ni tanya soalan-soalan orang kampung kan, tanya relax-relax macam tu. Setujulah. Okey. Jadi kawasan kampung kita ni semua dah ada geran kan? Dah ada. Okey. Setuju ke tak tuan kalau saya katakan tanah yang tuan buat rumah ni ada geran juga. Setuju ada geran. Dan setuju ke tak geran dia atas nama plaintiff. Dia pun betul lah, geran tu atas nama plaintiff. Jadi bila geran tu atas nama plaintiff, setuju ke tak bahawa tanah ni cara rekodnya adalah milik plaintiff? Setujulah. Jadi tuan buat rumah di atas keping tanah yang mana plaintiff ada geran, bermaksud tuan mencerobohlah tanah plaintiff. Saya tak setuju. Yelah, tapi tuan tadi cakap bahawa kepunyaan sesuatu tanah tu adalah bergantung kepada geran. Dan tuan sendiri setuju dengan saya bahawa ini adalah kepunyaan plaintiff. Jadi bila tuan buat di atas tanah plaintiff, maka tuan mencerobohlah. Setuju tak setuju? Setuju tak setuju? Kan? Ataupun saya tak faham lah soalan awak ni. Lepas tu kalau dia dah terjerat, kita jerat dia lagi. Tapi tuan tadi katakan geran tanah tadi adalah bukti kepunyaan seseorang tanah tu kan. Saya nak tanyalah tuan, tadi tuan dah setuju dengan saya. Tuan setuju ke tak bahawa tuan tak ada pun geran di atas nama tuan? Saya memang tak ada geran. Jadi kalau tuan tak ada geran, sekeping pun atas nama tuan, macam mana tuan boleh buat rumah di atas tanah orang lain? Yelah, kita kampung buatlah kan. Orang bagi buat rumah, kita buatlah. Tak, bukan itu isunya. Tuan setuju atau tidak bahawa tuan telah buat rumah di atas tanah yang bukan milik tuan, di atas geran yang dikeluarkan oleh pejabat tanah? Yang tu saya setuju lah. Habis. Okay? You see? Ini contoh simple orang kampung saya lah. It can be complex, but this is just to show you how to ask baby steps question. I hope by now you nampak. You faham. Ini yang saya cakap baby step. So dalam every point, you want to baby step. You want to lay down the foundation. Ask witness to agree with basic things before you jerat dia. Inilah skill yang paling penting dalam cross examination. You kuasai yang ni, you can cross. Right? So banyak lagi lah contoh. Saya buat benda ni all the time. Dan all the time witness akan terjerat dengan saya. Sebab benda-benda macam ni lah. Kita tanya simple-simple je dulu. Okay? So far ada soalan? On the 3 commandment. Leading questions only. I already said to you, you must ask leading question. Because you can. You can ask leading question, you only ask leading question. Unless other question is required. Kalau your strategi tadi untuk tanya non-leading question, untuk jerat witness, itu dah advanced level, you boleh tanya. Kalau you betul-betul dah cakap. Tapi kalau you tak cakap,